So given that this session is going to be really, really packed in terms of content, let's start with the opening remarks right away. And then hopefully a couple more people will trickle in over time while we're at it. So my name is Niklas Geig. I'm the chair of the Young AIPPI Members Committee, and for our opening welcome remarks for this mid-session of the summit, we started it yesterday, you may remember, hopefully you were all there, with a global session and then an AI learning and prompting session. We are having with us today from the Secretary General team of AIPPI, our very own Debbie David, Assistant Secretary General. Debbie, we're so happy to have you with us, and we're very much looking forward to your opening words of wisdom.
Thank you, Nicholas. It's such a pleasure to be here, and good afternoon to the Asia Pacific crowd and to the Asia Pacific session. I hope that some of you managed to attend some of the sessions yesterday for the global session. I found them all really interesting, and the AI session really taught me new things, as they do all the time, about how to use tools in practice and really how it can continue to evolve what we do day to day, really. So I'm really excited that we get to continue on another journey today, starting now with our first satellite session for Asia Pacific. And just on behalf of AIPPI, just welcome to this session. Welcome to the second day of the summit. And we're just really excited to continue the work that we do among the young member community of AIPPI, which Nicholas will talk about right after me. So the idea of the satellite sessions, for those of you where it's your first time, is really to put a session that's in a time zone that's comfortable for participants. And it also talks about topics that might be relevant to our region. And so that's really the basis of why the satellite sessions exist as part of our program. Really looking forward to the session. I know we've got a lot of speakers, so I'm not going to say too much because I want to give you all the time, speakers and moderator, for your session. But I just want to encourage those of us who are participants to just really participate in the session. Ask any question that you like, and I'm really looking forward to the time ahead that we have together. I want to thank the Young Members Committee of AIPPI for putting all of this together, as well as moderator Chihiro, yourself, and the panel of speakers that are speaking today. Thank you all so much for your contributions towards our community. And last but not least, for those of you that will be in Hamburg, I look forward to seeing you there in person. And so with that, thank you very much for the opportunity to speak. And Nicholas, I'm going to hand the session back to you.
Thanks so much, Debbie. And we're so happy for the support from SGT, of course, which no one probably shows better than yourself, having been present at every session so far from this year's summit, which is already a big achievement because we all have, of course, our own work to do on the side as well. So we appreciate it a lot. And then to add on in terms of content to your remarks already on the work of our Young Members Committee and on the summit program. So here is the summit program again in a glance. We've just briefly talked about global and ideas exchange sessions, which we had yesterday. Today, as Debbie already explained it, we are having the satellite sessions at more locally convenient times. So please make sure to also tune in for the following two satellite sessions after that. Hopefully we'll see you there as well. Here's a brief overview over our committee. You will see several of our members in this call, particularly also Chihiro, who's our moderator for this session. And the work that we are doing, just very, very briefly, comes all down to that. So we're trying to build a very big network for every one of you, possibilities to exchange between young professionals, to grow together, to get some speaking experience also, and to better understand and discuss and learn about the workings of AIPPI in general, I would say. So this is a great forum if you want to involve yourself more in AIPPI, if you want to grow as a practitioner, then you can always reach out to us and we'll make sure to get you involved and help you along your way in the IP space and bigger AIPPI world. So having said all that, we of course also have other events. After the summit, Debbie already hinted towards the AIPPI World Congress. There we will have the forum, which is our big young member in-person event. Then there are certainly also national young member events. These are hosted by the national group, so not our committee, but we are often involved or we know the people who are working in that field or in that specific national group. So if you are part of or want to become part of a national group, we are planning events on a national level. Please also reach out to us, let us know. We can always help and share our experiences and facilitate much of your work. One of the examples that I would want to give personally is, for example, trilateral seminar of young members that was started last year with an event in Paris by the French group. It's now being continued by the Italian group in Milan, and hopefully after that, also the German group will be able to host one. So this is one specific example of how national groups, young member national groups can cooperate as well to create something bigger, for example, on a regional level. Finally, looking ahead into 2027, we will also have a couple of events there, of course, hopefully starting with something at the midterm meeting. And yeah, stay tuned. I'm sure there's a lot coming up going forward as well, and we're happy to have you with us then. Having said all of that, I'm happy to hand over to Chihiro for the actual session and very much looking forward to everyone's presentation. Chihiro, the floor is yours.
Thank you, Nicola and Debbie. Good afternoon, everyone. My name is Chihiro Bain. I'll be the moderator for today's Asia Pacific session. Before we get started, just a few quick housekeeping notes. First, please note that this webinar is being recorded and will later be published on AIPPI's YouTube channel. If you have any questions for the speakers, please submit them through the Q&A box. We will address all questions during the Q&A session at the end of the webinar. There will also be a short survey after the webinar, and we would greatly appreciate your feedback. Thank you very much for your cooperation. Now it is my pleasure to introduce our first speaker, Ron Fee. Ron has graduated from Fordham University with a LLM degree in intellectual property law. Before joining the firm, Ron had an internship at Finnegan Henderson, Faribault Garrett and Dana LLP Washington. Throughout profound experiences in assisting global IPR clients, he has in-depth IP expertise not only in China, but also the US, Europe, and other major areas. Ron primarily has been focusing on client relationship management by coordinating outbound cases since 2015. Also, Ron has been assisting global startup clients to design their China entry IPR strategy in a cost-efficient way. With his concrete legal background in China and in the US, Ron has been providing overall IPR protection strategies to major China and US clients, including some leading companies in high-tech, food, pharmaceutical field. Ron is a frequent attendee of INTER, AIPPI, AIPLA, MARCS, and he presents in many reputable global seminars on IPR strategies in China. Ron, thank you very much for joining us today. The floor is yours.
Thank you, Chihiro, and thank you for Nicholas and Debbie for hosting this great event. I think Young AIPPI Members Committee is a great platform for all us young practitioners for IP to communicate and to present ourselves. I think it's a great opportunity and look forward to seeing more events like this. So I'm going to share my presentation here. So on the June 26, 2026, China passed a brand new trademark law. It will take into effect on January 1st, 2027. This is not a small update. It is the first complete rewrite of the law since it came into effect in the 1983. So a little bit background introduction about myself. I'm a trademark attorney and director of business development at Chauncey & Partners, serving as the firm's primary point of contact for US and international clients and referral partners. I'm also the firm's regular representative of international IP events, besides of AIPPI. I'm also the INTA's member of global. I'm also the Global Advisory Council of INTA, reporting to the board members. I'm also the 2025 INTA Rising Star and also the chairperson of the brand restriction subcommittee. And also I was in the 2023 WIPO China delegates, served as a coordinator and a translator for China authorities. So in today's presentation, in the following 10 minutes, I will cover three things. First, where Chinese trademark practice stands today. And second, what actually changes under the new law. And third, what to expect going forward and what brand owners should to know. Let me start with the big pictures. China runs the largest trademark system in the world by a wide margin. In 2025 alone, over 4.2 million trademarks were registered. By the end of 2025, there were nearly 50 million validated registered trademarks in China. To put that in perspective, that is more than the rest of the world combined. And there's three features to define the current practice environment. First, China is strictly first to file. Rights go to whoever filed first, not whoever used the mark first. This is the single most important rules for the foreign companies. If you enter the Chinese market or even just manufacturing in China, without filing early, someone else may register your brand before you do. And second, the system is fast and affordable, but crowded. The average examination period is now about 4 months, one of the fastest amongst major jurisdictions. Filing costs are low, but the flip side is a crowded register. Millions of marks on file mean a higher chance your application hits a prior conflict marks. And third, bad faith filing remains the #1 pain point. Trademark scouting, where someone registers a foreign brand, celebrity name, or a popular design purely to sell it back or block the real owners, has been a persistent problem. The 2019 amendments started to address this by rejecting the bad faith application not intended for use. Enforcement authorities and courts have become much tougher over the past 5 years. But scouting and hoarding have not disappeared. They have simply become more sophisticated. So this is exactly the background against which the new law was written. So let's look at the new changes. Officially, this is a revision, not an amendment, meaning a systematic redesign, not a patch. Let me walk through the changes that matter most in practice, comparing the old and new. Change #1, a full toolkit against bad faith filing. Under the old law, fighting in Scholar usually means filing opposition and invalidations one by one, slow, expensive, and very reactive. The new law attacks the problem across the whole chain. Stricter rules against malicious application and hoarding, tighter supervision of the registration process, and heavier legal consequences for bad actors. The message from the legislator is clear. Trademark exists to be used, not to be treated like a lottery ticket. Change #2, use obligation get real teeth. This may be the biggest shift. The old system was register-centered, and the new one is use-centered. Two examples. First, the new law creates liability for misleading use of the registered trademarks. For example, using your mark in a distorted way that confuses consumers, authority can order correction, imposes fines of up to 5 times after illegal turnovers, and in serious cases, revoke the registration entirely. Owning a registration no longer protects you if you may use it improperly. You can see in the picture, there's zero additive claims in the soy sauce or the handmade claim of the dry noodles, and that will be not allowed in the new trademark law. And second, under the old law, A trademark unused for 3 consecutive years could only be cancelled if someone applied for cancellation. Under the new law, the trademark office can cancel unused mark on its own initiative, ex officio. This is designed to clear deadwood from the register free up some namespace. So the practical takeaway here is keep solid, dated evidence of genuine use in China for every important mark. Under the new law, registers, but sitting in the drawer is a very risky position. Change number 3, enforcement gets stronger for right holders. 2 improvements here. First, damages now explicitly include the reasonable cost of stopping the infringement, investigation fees, legal fees, and other reasonable expenses. Second, the law also targets abuse from the other directions. Bringing trademark litigation in bad faith can now trigger penalties and civil liabilities. So the sword is sharper, but it cuts both ways. Change number 4, new mark types and modernized procedures. The new law expressly added dynamic marks, moving logos, you can see in the Toshiba ones, animations, to the list of registrable signs. Alongside sounds, color, and the 3D shapes, it also introduced a suspension mechanism during examination. If your application is blocked by a prior mark that is being challenged, examination can be paused instead of forcing you to file endless backup application. And change number 5, much tougher rules for trademark agencies. Fines for agencies misconduct jump from a range of 10,000 to 100,000 RMB to 100,000 RMB to 200,000 RMB. And agencies are barred from using newly created entities to file mark in disgrace. For clients, this means the quality gap between complaints, professional firms, and low-cost volume filers will widen. Choosing the right agent matters more than ever. So what happened next? Where does this go from here? Timing first. The new law will take effects on January 1st, 2027. Before now and then, CNIPA will issue implementing regulations and detailed rules. For example, how misleading use will be defined and how ex officio non-use cancellation will treat legitimate defensive registration. Watch this space closely. The details will shape day-to-day practice. For brand owners, I think there's 3 action points before January 2027. First, audit your Chinese portfolio. Identify marks that have not been genuinely used in the past 3 years. Decide which ones to put into real use, which to support, and which should be documented, use evidence, and which to let go. Second, review how you actually use your marks. Make sure the marks as used matches the mark you registered, and that nothing in your usage be seen as misleading. Number 3, reassess your enforcement strategy. With lower bar for punitive damage and recoverable enforcement costs, litigation in China becomes more attractive for right owners. The bigger picture, this revision continues as a clear decade-long trend. China is moving from quantity to quality, from the world's biggest register to a register that actually reflects real brands in real use. With stronger protection for genuine rights holders and less tolerance for gaming the system. For legitimate business, foreign and domestic alike, this is a good news. To sum up in one sentence, register early, use genuinely, keep evidence, and be ready to enforce. The new law rewards exactly this behavior. Thank you so much for your time. Chiro, back to you. Chiro.
Thank you very much, Shiro, for your presentation. Now let us move on to our next speaker, Fiona Zhang. Fiona is a veteran IP specialist focusing on trademarks, copyrights, and domain names. She boasts full-cycle expertise covering trademark searches, filings, rejection reviews, opposition, disputes, assignments, licensing administration, customs recordation, and infringement surveillance with solid command of cross-border trademark filing and protection rules. Drawing on global brand strategy insights, she has crafted holistic brand protection plans for domestic and overseas firms to preserve their intangible asset value. Having practiced at Beijing law offices and Kanjian partners, Ms. Zhang combines top-tier legal work with frequent industry outreach. She has delivered keynote speeches at leading global IP events, including AIPPI, Inter, and CASA, gaining wide acclaim from international practitioners. Since joining Sun and Chan IP, she has broadened her IP legal service portfolio. As an expert appointed by CNIPA, she liaises closely with key global and Chinese authorities, WIPO, Inter, Interpol, Europol, EU IPO, UK IPO, as well as China's Ministry of Commerce, SAML, Ministry of Public Security, courts at all levels, and General Administration of Customs. She regularly takes part in policy workshops, law enforcement coordination, and training to discuss IP protection, cross-border anti-counterfeiting collaboration, and advance relevant international enforcement projects. She excels in non-litigation work such as bilingual contract drafting, review, legal translation, IP filing recordation, administrative enforcement, e-commerce platform, complaint handling, and commercial negotiations. She also handles trademark, copyright, and domain-related civil and administrative litigation to secure optimal outcomes for clients. Dedicated to tailored all-round IP solutions, Ms. Zhang is a reliable multidisciplinary IP expert trusted by clients worldwide. Fiona, thank you for joining us today. The floor is yours.
I think she's muted.
Oh, sorry. Oh, okay. Thank you. Thank you so much for the reminder, and really appreciate for such chance to be here and to share something about the trade secret in China. And currently, given right now, we all know that currently we are living through an era where digital assets defend corporate survival, and the relevant also algorithms, and also the source codes and the AI training data, and also the big data pools are no longer merely the technical byproducts, but also the irreplaceable lab that keep everyone innovative business competitive in today's markets. So today I will share something new about the trade secret law firm and the law and also the regulation in China. And the first one, let's just to say that something about the trade secret. And let's learn our foundational understanding that the trade secret in the digital age far beyond the old school blueprints and also the chemical formulas, falling into three high-value confidential assets buckets. And first, the core technical assets, namely the AI models, also the source codes and the AI training database, and the foundational backbone of all digital products, online services, and the AI models. And second, user and the commercial data, and user portraits, and also the exclusive clients list, and together with the big data and user behavior analysis models, and also some competitive rules in the worldwide, and also the third one is the strategic and the supply chain confidential materials, such as the corporate roadmaps and the full marketing and pricing playbooks and digital supply chain archives, and some channel resources, which directly keep your bargaining power in the market. And the trickiest characteristic of digital leakage is overlapping internal and external threats compounded by technical risks, creating a cascading risk, multiple actors effects, and I've solved the most frequently the relevant data, namely by the recent with the data of the course through the 2014 to 2024. And currently, for the based on such data, statistics, we can see that first, the total number of the trade secret cases climbs steadily every single year, with technical secret cases heard by the Supreme People Courts. And also this clearly indicates that the digital assets are growing steadily in commercial value, and also the judicial protection is being strengthened step by step in current in nowadays. And second, the step segmentation in case types. Technical secret disputes make up nearly 67% of all litigation, while business information accounts for just 35%. And technical assets such as the AI data and also the AI models, the codes, and the production process remains the primary objects of the corporate lawsuits. And the third, severe geographic concentration. Over 40% of all national cases are concentrated in Guangdong, Shanghai, and Beijing. In these tech hubs, packed with high-tech firms and cross-border trade, infringements run sharply and force the selected picture of litigation outcomes, and courts award an average compensation of nearly 7 million RMB to winning claimants, proving judges who recognize the substantial economic value of the data assets. And the other one will be the overall win rate sits at merely around 27%, held back entirely by the massive third challenge of securing ministerial digital evidence. And we will also see some typical case, and this is similar. But the first one is for the Sheng Yincanmo data case. And in this case, the Sheng Yincanmo case, which fully fills the judicial gap in safeguarding the data rights within the digital economic framework. And the core facts of this dispute, namely that industrial competitors deployed mice crawlers and the correct platform protection interface via electronic or to the illegally serve massive volumes of non-public business data by the AI training on the platform. And the infringers then replicated a rival data analysis platform, directly use the customers and also misleads the customers and seize the market share. And for decades, the traditional IP frameworks only covered chemical formulas and static claims list, leaving the legal states of massive Denmark operational data and this case erases the gray area entirely, and the court's core judicial reasoning that the three layers, and the first one is the dynamic layered data accumulated through the continuous corporate operations, represents sunk costs and also carries direct the commercial value, and compared with the complete confidentially safeguards, including log access controls and data, and also the full access logging, and the data fully satisfies the three satisfied the trade secret elements. And namely, the first one is for the security, and namely that is the commercial value and the reasonable protective measures. And the second is the defendant's malicious by causing and also using the data for the marketing and for the commercial use. And the third one will be the defendant demonstrating that the subjective malice and large-scale harm. And
sorry, Fiona, can I interrupt? Sorry about that. So in the presentation, we only see the first presentation. So yeah, maybe you should go.
Can you close the slides and reshare them?
Sorry. So thank you, everyone. I didn't want to stop here. I didn't want to stop her, so I'm so sorry. And thank you for pointing it.
Yeah. So it's available to see the slides on the screen right now? Oh, now?
No.
Cannot, right?
No, I think your screen is frozen.
Oh, I'm so sorry, and I will share that again.
Yeah, now it's working.
Let me see that. So it's available to see the slides on the screen right now?
Yes.
Oh, okay. Okay.
But
And
not in
as
presentation mode. So if you can put it in presentation mode, I think it would be even better for everyone.
Oh, okay. I will also share with everyone through the chat column. Yeah. So the next one, I just want to continue about the case, namely that the Shinji this case, and this is just to the first trade secret case in China with the high compensation. And the other one is also the same, but for the second one, due to the time limitation, I just want to introduce that in the trade secret cases, and the applicants or the right holders could also go through the criminal and also the civil and administrative actions together at the same time. And the last one is also the evolution of the Chinese law for the trade secret. And in the past, we will also use the trade secret protection in the unfair competition law. But right now we have the new regulations issued and also implemented this year. So we will also see some outstanding points of such law. And in this part, and we will see that the first outstanding point will be the object and infringement definition. And here we can see that some electronic intrusion and also some uncompleted data will also be protected. And the other one will also be the risk control and the evidence rule. And here, apart from the normal contracts or the management and the relevant technical measures will also be required to protect the trade secret. And the other one will be the legal liability. And here, so in addition to the infringer and the relevant supporter or the partners of the infringers will also be required to undertake the legal liabilities. And here is some the new trends in this part. And we can see that the first one will be also the protection scope expansion, namely that some uncompleted data will also be protected. And the other one will be the infringement targeting and previously combining the digital infringement methods, and also some intrusion and unauthorized downloading will also be targeted. And the other one will be the compliance upgrade with the technical measures and also the insight management for the contracts. And the other one also the legal deterrence will be enhanced, namely that for the trade secret, and you can use some legal actions together, namely that the administration actions, civil and the criminal actions, so the total compensation will be enhanced. And here is some points faced by the digital enterprises, and we will see that for the assets identification, and we also see that in China enterprises, they also encounter the huge risk for the trade secret released, and also they send some contracts to protect, but this is not enough, and we will see all new measures and new risk in the digital developments. And here are some suggestions. And here I just want to further to suggest that firstly to build systematic construction and roll out the integrated protection system, complete the full enterprise classification and also the ownership confirmation and the value assessments for all trade secrets with the standards confidential access. And the other one will be to establish the full life cycle management, including the employee management when they go into the company and then when they leave out. And we will also see all the files preservation, and this will be quite important for the future litigation. And the other one will be the upgrade of the digital technology defenses in order to deploy some DLP or the trade secret AI tools to try to block some risk or lower the risk that for the employees to take over some trade secret outside of companies. And the last one, I just want to briefly outline the long-term national IP roadmap for the coming years as the AI and the industrial internet and the cross-border digital trades continued to evolve at speed. So IP regulatory rules will be quite updated to address emerging data infringement risk, such as so we should to reshape a fair and also the innovation-friendly global global market order. The new provisions will probably provide fair competition in the data sector and break the platforms to protect the trade secrets. And meanwhile, the newly enacted jurisdiction clauses also enable authorities to pursue overseas and entities that steal the domestic companies' trade secret. So this is the future and the brief summary of such trade secret protection in China. So thank you so much for your time, and I'm so sorry about the stopping and the frozen of the slides, and we also share the slides to all of you to see something more. Thank you so much for your time.
Thank you, Fiona. Now let's move on to our next speaker, Aakriti Vadhera. Aakriti is a partner at Khan and Krishmi, a leading intellectual property law firm based in New Delhi, India. She's an Indian patent attorney, trademark attorney, and advocate with a background in electronics and communication engineering, enabling her to bridge complex technology with practical legal solutions. She holds an LLM in intellectual property law from the George Washington University, Washington, D.C. Aakriti advises multinational corporations, research institutions, and innovative businesses on patent prosecution, patent litigation, trademarks, advertising and marketing law, copyright, and data privacy. Her practice has a particular focus on electronics, telecommunications, software, and standard essential patents, alongside advertising law, influencer marketing, and technology regulation. She has prosecuted hundreds of patent and trademark matters, regularly represents international clients on Indian IP strategy, and is an active speaker and author on emerging issues in intellectual property, advertising, and artificial intelligence. Aakriti is also the winner of the 2023 USPTO Regional Patent Drafting Competition, reflecting her strong technical and drafting expertise. Aakriti, we are happy to have you here today. So the floor is yours.
Thank you, Chihiro, and thank you, everybody. So I've had the opportunity of presenting in the Young Members Summit last year as well. And last year, the topic was standard essential patents. And while those are very interesting and very lucrative, I thought this year we could switch and I could maybe present on something more fun and something which is more entertaining, perhaps. So just allow me to share my screen. Give me a second. Okay, can you see my screen?
Yeah.
Okay, great. So yeah, first of all, of course, my topic is about ambush marketing and the protection of personality rights of athletes in India. So why this is relevant for you? Because as a IP attorney and more particularly as a trademark attorney, every now and then, especially now with FIFA running and of course all over the world, there are so many sports events. Ambush marketing is very rampant. And to explain what is ambush marketing, I think it's better to just show you a video because I think that would be better. So let's get to it.
Officially, cricket is played in whites at a leisurely pace. The official players are gentlemen, restrained. You have to drink the official drink. There. Pepsi. Nothing official about it. Nothing official about it.
Okay, so like I said, in 1996, Coca-Cola paid to be the official beverage sponsor of the Cricket World Cup in 1996. Pepsi had in fact lost the sponsorship bid to Coca-Cola, yet Pepsi ran this massive campaign around the tournament anyway, without ever claiming to be the official sponsor. In fact, their whole campaign was based on nothing official about it, and they managed to steal the show from under the feet of Coca-Cola. Even today, 30 years later, this ad is remembered, but the Coca-Cola official sponsorship status is not. And that is ambush marketing in a nutshell. As explained by Delhi High Court, the phrase ambush marketing is used by, now this case is of course from 2002, and at that time the Delhi High Court did hold that the phrase ambush marketing is used by marketing executives only, but it is different from passing off. It is not moment marketing either. It is something entirely different. Ambush marketing is basically an opportunistic commercial exploitation of an event where the ambusher never actually claims a connection to the event. They simply piggyback or hijack on the attention that the event generates. It is not the traditional passing off because there is no false claim of connection. It is not moment marketing because moment marketing is an agile, real-time response to a virtual cultural event. It is, in simple language, ambush marketing is a deliberate, competitive strategy to hijack an official event's multi-million dollar spotlight without paying the sponsorship fee. So the obvious question that comes to mind is it legal? Well, as long as there is no infringement of IP, I guess it would have to be legal, right? But let's try to answer that question again when we have a little more information about ambush marketing. So there are two different types of ambush marketing. Yes, there's indirect ambush marketing and there is direct ambush marketing. So what is direct ambush marketing? It is the intentional, unauthorized use of an event's IP, such as trademarks, logos, copyrights, or other official imagery, to intentionally mislead a consumer into believing that the brand who is performing the direct ambush marketing is an official sponsor. Because direct ambush marketing is almost always straight up IP infringement, it is illegal and thus rarely practiced by reputable brands today. However, there are different types of direct ambush marketing which are not IP infringement and therefore legal also. For example, on the left, you have predatory ambushing, which is actually actively undermining a rival's official sponsorship. The campaign from last slide with Pepsi was an example of predatory ambushing. This, on the left, is a more recent example from India, the Indian Premier League 2017, which is like India's cricket NBA. Vodafone was the official sponsor, and Jio, which is India's largest telecom company and with a massive patent portfolio, ran a highly visible campaign at the same match, essentially stealing Vodafone's thunder under its own backyard. Then on the right is coattail ambushing. Coattail ambushing occurs when a brand directly sponsors an individual athlete to ride the coattails of a major event's massive visibility without paying for the official event sponsorship. So this ambush marketer, they are not sponsoring the event, they are sponsoring the athlete instead. And a classic example is when Puma sponsored the sprinter Linford Christie at the 1996 Olympics. Puma had him wear custom contact lenses featuring the Puma cheetah. It made such a noise that it completely hijacked the global close-up broadcast cameras right from under the official sponsor Reebok's nose. And coming to yes, indirect ambush marketing. Indirect ambush marketing is more subtle. It is the legal use of generic imagery, theme-based messaging, or public events right outside the venue to intentionally link a brand to a major event without infringing on its actual trademarks. There are, of course, different types of indirect ambush marketing as well. For example, on the left is associative ambush marketing, which involves the use of generic themes or wordplay to trigger a mental connection to an event without using its trademark. For example, the company Paddy Power bypassed the strict London Olympics Games Act 2006, which was happening during the London Olympics, and which had restricted the running billboards claiming to sponsor. So Paddy Power had run billboards claiming to be the sponsor the largest athletics event in London, which cheekily referred to a literal egg and spoon race, which they had funded in London, France. So this is associative ambush marketing. On the right is then insurgent ambush marketing, which relies on sudden on-ground disruptions. For example, last year's Mumbai Marathon, Nike executed this by setting up massive unannounced guerrilla cheer zones and distributing performance gear right on the public edges of the course, completely stealing away the spotlight from the official sponsor, which was ASICS. So basically, it is how creative can you be in your marketing campaign without paying the millions of dollars in official sponsorship fee, and more importantly, without breaking the laws of IP. And I guess that's where we as IP lawyers come in, right? And I do want to flag that this is ambush marketing does not have to be only about sports. Brands run these same playbook around any high attention event, award shows, public product launches, and even competitor campaigns. The ambush marketing you will see today generalize well beyond stadiums. So the question now comes, how is ambush marketing actually regulated? IP law, of course, protects against direct ambush marketing when there is, in fact, trademark and copyright infringement of protected marks like the Olympics rings or passing off where consumers are misled into believing that a brand is an official sponsor. Then there is, of course, copyright infringement laws where there is copyright infringement of the official mascot, the slogans, or the jingles. But like we just saw, ambush marketing is hardly ever straight up IP infringement. It is much more creative than that. And therefore, there exists event-specific rules which event host countries and organizers create before a large-scale event like FIFA. For example, this year, Mexico reformed its rules to protect the official sponsors against indirect ambush marketing. How? By creating clean zones around venues where a brand may or may not market, word pairing restrictions like the London 2012 Act for the London Olympics, which criminalized the unauthorized commercial combination of words like Olympic, Olympian, or Olympics with any other combination of words like 2012, London, gold, silver, bronze, sponsor, or summer. And more such techniques to protect official sponsors against ambush marketers. And then, of course, there are contractual obligations. Sponsors negotiate first refusal rights on broadcast by third parties, no fly zones over the stadiums, and ticket terms that bar branded stunts in the stands, like Geo did. So as you can see, most of this is not built on a single unified statute anywhere in the world. It is a patchwork. So the next time you come across an ambush marketing case on your desk, beware that it is not as simple as it looks. It will require a lot more research. Which brings us now to India. So India, again, there is no unified statute, where we have ambush marketing laws. And India, because I'm from India, so of course I have to speak on India. And it is also very important, in my opinion, because Indian advertising marketing size as of 2026, I'm sorry, is $16 billion. So when you have such a huge advertising market, you cannot ignore it. Despite that, India has no dedicated anti-ambush marketing statute. Instead, we stitch together four existing frameworks. The Trademark Act, which protects against trademark infringement, the Copyright Act, which prevents unauthorized use of logos, jingles, and original works, the Consumer Protection Act, which deems a false claim of sponsorship as an unfair trade practice and empowers the Central Consumer Protection Authority to impose penalties running up to 55,000 US dollars for repeat offenders. And then there is a code of advertising self-regulatory body, ASCI, that catches even indirect misrepresentation through visual or tonal cues suggesting sponsorship and can order an ad's withdrawal. Having said that, because ASCI is self-regulatory, it does not have teeth. So the worst that it can do is escalate it to the Central Consumer Protection Authority, who can then order penalties and takedowns. Now coming to how India actually handles ambush marketing in reality and not just on the law. So unfortunately, so far we only have one case that is on ambush marketing, which is back from 1994, where the Delhi High Court held that no brand can claim monopoly over generic descriptive terms like World Cup, and ruled that ambush marketing via ticket contests, like holding contest takes you to the World Cup, things like that, they do not actually constitute a legal wrong as long as there is no consumer confusion, trademark infringement, or false claim of official sponsorship. So with no statute or case law to lean on, the Board of Control of Cricket in India, which is the biggest cricket body in India, has simply written its own guidelines governing the use of legal marks, of a league's mark and footage, which basically translates to private regulation. And on your phones right now during FIFA or in India during cricket matches, quick commerce apps like even Domino's for that matter, fires witty event-timed push notification during matches. No logos, no claimed association. So let's revisit the question again. Is ambush marketing legal? The answer remains the same. Yes, as long as it does not infringe IP. More importantly, is it allowed? That answer depends on the country and the particular events, rules, and regulation. Which now brings me to my last slide, which is closely tied to this particular topic, which is athletes' own rights to publicity or to personality. Indian courts increasingly protect an athlete's persona from unauthorized commercial use as a form of false endorsement. This is broad. It covers image, name, likeness, voice, and persona, going well beyond traditional false advertising. Although, having said that, memes, satire, news reporting, and fantasy sports statistics remain protected speech. Athletes also actively protect their personality rights by themselves. For example, this Indian Olympics winner Manu Bakher last year, her lawyers sent legal notices to 24 brands for unauthorized tributes, posting her images on Instagram, congratulating her, which it was not, which the brands which Manu was not actually associated with. So practically, most athletes now register their names, nicknames, signature, and jersey numbers at Trademark. In the US, we have Matthew McConaughey protecting his all right, all right, all right. In India, we have a lot more athletes as well protecting their trademarks, like Virat Kohli. And the CCP's 2022 endorsement guidelines require that endorsements reflect a genuine, current opinion without any material connection, with the material connection disclosed. And that is all from me. So thank you, everybody. Thank you very much.
Thank you, Aakriti. Now I would like to introduce our next speaker, Giacomo di Grazia. Giacomo is an IP lawyer at Chiomenti, a leading Italian law firm where he assists Italian and international clients on intellectual property and information technology matters, with a particular focus on copyright, trademarks, domain names, and patents. His practice centers on advisory and transactional work, from the negotiation and drafting of agreements to the IP aspects of corporate transactions, technology licensing, and trade secret protection. Giacomo's work also extends to the creation and management of joint ventures for the development and industrial application of intangible assets, as well as to the economic valorization of intellectual property, including related financing agreements and investments linked to patents, trademarks, and other IP rights. He further advises on the intellectual property implications of emerging technologies, including AI-generated content. He regularly advises clients across the luxury, retail, technology, and food and beverage sectors. He is a member of AIPPI and LES and is a frequent speaker at events sponsored by the main Italian chambers of commerce and by national and international associations. Giacomo, thank you for today. The floor is yours.
Thank you. And thank you everyone for letting me speak here. I will share my presentation. Okay, tell me if you can see it.
Yes, we can see it.
Okay, perfect. As you can see, I will talk about ambush marketing again, and I will start by saying that I'm lucky because this year we had the chance to host the Milan Olympic Winter Games. And since I'm based in Milan, as you can imagine, a lot of clients wanted to have advice on this matter, because we had the Olympic Games at home in the very meaning of the word. And we start by saying that Aakriti has just shown us how ambush marketing works in principle and how a common law system like India handles it. And we will talk about the ambush marketing related to Milano Cortina events and the ATP finals in Turin as well, because ambush marketing applies as well to every major event, not only the Olympics, which was, however, the starting point. And over the next few minutes, I'll trace where Italy started, what changed in 2020, and how authorities enforced it around the games. So let me start with the picture as it stood before 2020, because it explains why Italy felt the need for a special law. Before 2020, there was no anti-ambush statute at all. A practitioner has to improvise with the general tools of the general law, so the civil code, consumer code, and the IP code. First, unfair competition under Article 2598 of the Civil Code, Italian Civil Code, and the classic parasitic hookup to someone else's event, and it worked, but only after the fact in civil litigation, so it was very slow. Second, the consumer code against advertising that misled the public into thinking a brand was an official partner, useful, but assessed case by case with no focus on events, and once again, too slow for the pace of the events. And third, trademark and IP law, but that only works where a protected asset is actually used. And we've seen with Aakriti that is not always the case. It is useless against a campaign that is logo-free and purely evocative, which is exactly how modern ambush works. And there was a couple of special laws working only for the events in the past Torino 2006 Winter Olympic Games, but that only lasted for that event only. That is what changed in March 2020. A law passed, and it was built deliberately for Milano Cortina event and the AIPPI finals in Turin. The heart of Article 10 of that law, which bans parasitic, fraudulent, deceptive, or misleading advertising and marketing activities connected to major sporting and trademarks, trade fairs events. Crucially, the law typifies 4 specific conducts, which you can see here. One, creating an indirect association that misleads the public about who the official sponsors are. 2, falsely representing yourself as a sponsor, licensee, or authorized partner. 3, unauthorized promotion on the occasion of the event, and so making a connection with the event. And 4, selling or advertising products with logos or indicia that deceive the public about a license that is not actually there. Not the shift in language on the conversion from parasitic advertising to parasitic activities. So it's very large and broad, this wording, and widens the net from communication to commercialization itself. Now that the regime is effective, this is the enforcement design, which is one of the main part interesting for us. And enforcement is administrative and very, very fast. The Competition and Consumer Authority, AGCM in Italian, has competence over these conducts with interim powers, and it can use while the campaign is still live, and has an operational arm, which is the Guardia di Finanza, which is like a police for these kind of activities for fraudulent, for example, financial matters, and here for the event as well, which can seize or record evidence during the event, even on its own initiative. So they can walk around the event and spot maybe an illegal activity right away and stop it right away. Importantly, these tracks are cumulative. Administrative fines sit alongside civil injunctions and damages, and even criminal exposure where relevant. Two numbers to keep in mind. Fines run from 100,000 up to 2.5 million euros per violation. But the most important thing, I think, is that there is a possibility for the Guardia di Finanza to stop the illegal activity right away. And that is maybe more relevant and effective than the fines per se. And then the time frame, the long window. Article 11 says that it runs from the registration of the official signs. In the Milano Cortina Winter Olympics case, it was around 2018, until 180 days after the event closes. And one more point on AIPPI, trophy images are now registrable as well-known signs, and so CAP-inspired creativity risks have the ambush law protection and the trademark infringement one as well. So two tracks protection. So how do courts actually apply this? The key decision is the famous Zalando case, where Zalando published billboards close to the football village, with a claim saying who will be the winner, with a lot of flags from the countries participating to the event. It was the Euro 2020, the football tournament, and it was sanctioned by the GCM and then confirmed by the highest authority, administrative authority, which is the Council of State. And the holding is the single most important takeaway. The assessment is holistic. It looks at the overall framing, and the three factors combine. Proximity to the venue, it was very close to the football village. Timing on hot dates, so of course, the closer you are to the event and the higher the attention is. And graphic or textual cues. So if you are referring even indirectly to the event or to something related to the event, it can lead you to the violation. The court here was explicit, and the violation exists even without any official assets. So no logo, no protected trademark. Whenever the combination of place, time, and cues leads to the average consumer to assume the brand is a sponsor or an authorized party, that leads to a violation. And the other point worth flagging is the nature of the protection. It is the public interest. It protects consumers, not only the sponsors. And the administrative routes expressly coexist with private civil remedies, which are always in place, and so the sponsor may ask for damages. this was not theory. It played out in real time. We've seen in the Milano Cortina events with tons of advertising campaign being stopped. I had the chance to speak with the former head of IP of Milano Cortina, and he told me a lot of stories about the continuous work of the Guardia di Finanza and the Milano Cortina staff to block campaigns before they started, even in the physical one and the digital one. On the enforcement side, GCM opened proceedings against fashion and retail campaigns, social and out of home, and evoking or not the rings, hashtags, and games iconography. And the response, as I told you, was very rapid, and the takedowns, the moral suasion, measures taken in hours rather than weeks or months, because the goal was to act before the improper association consolidated in the public's mind. The focus was on hot context, physical and media proximity to venues, sensitive dates, and celebratory copy. For brands, the lesson is the risk threshold move with context. When place and time pushed, the same creativity that was harmless in a cold month became risky in the hot months. It was the reputational heat of being switched off mid-campaign that scared the companies from doing it. And so to wrap it up, we can divide the activities in three main flags. The red flags are the misleading and indirect association, false sponsor claims, unauthorized promotion at the event, evocative logo or indicia. Yellow were framing the sides, so the activities that are context related, team creativity without logos, typical palettes, pictograms, allusive claims or hashtags, and then of course the not event storytelling, co-location and timing, original assets that is free of any risk and is a safe harbor. However, most disputes live in the yellow zone, and the yellow zone is won or lost on context, as I told you. Here I brought three cases that happened in my practice. One was an in-store activation during the peak week in Cortina, the mountainside. During the peak week of the Winter Olympics, alongside the outdoor adjacent brands, and the client wanted to bring their little cart with coffee to be sold, and with the logos of this big coffee brand, and the coffee brand was not a sponsor. And of course, we stopped the physical activation and allowed only scrap digital content and published outside the sensitive window, and so we stopped it. Another case is an event look seasonal capsule. The same coffee brand wanted to put the logo on sporting gears like skis and suits, and with this kind of collaboration between that coffee brand and the sporting gear brand, we we said that the risk was there, but they could do it, of course, with no link with the event and no elusive claims. And we pivoted to a city and season brand narrative with original assets and neutral copy. And the line launched and at a contained risk. Last case was very peculiar because we had the opportunity to draft a contract between big company and one of the agency that managed the organization of the Milano Cortina Winter Olympic Games, and we had to produce a gadget, edible gadget, with the actual logo of the 5 rings of the Olympics. So the challenge was there because we had the opportunity to draft a contract of the official supply. So it was like something like an exception to the rule. Because there was the authorization of the Olympic Committee, and we worked on a very strict representation that no link with the manufacturer was made, no advertising, no sponsoring reference to the event, and just the name of the manufacturer following the law was written on a very small part of the package. And so we had the opportunity to follow that as well. So with minimal labeling and a non-sponsor disclaimer in the contract, and zero autonomous communication before and after the event, of course, because the protection lasts 180 days after the end of the event. And so we are still in that window. To wrap it up, we can live with the 3C protocol, I called it. Context: before you produce anything, map the touch points, the sensitive dates, and the venue proximity, and run a legal clearing on both the assets and the calendar. Creative scrub: before you publish, clean the visuals, the palette, the copy, and the hashtags until nothing alone or in combination points to the event. And of course, the course correction: before you go live, pre-assign who owns the go or no-go decision, and make sure takedown, replacement, or rescheduling can all be executed in hours. And if you remember one line from me today, make it the golden rule. If it can look like you're in, you're ready to close. Thank you, everyone.
Thank you, Giacomo. Now let us move on to our next speaker, Shinji Ishizu. Shinji is a partner in the intellectual property practice group of Oebashi LPC and partners in Japan. Shinji has a lot of experience with IP licensing and litigation of all types, including patents, trademarks, unfair competition, copyright, trade secret, and other IP-related issues in various technical fields, including pharmaceuticals, biotechnology, chemistry, mechanical engineering, electronic engineering, and computer software. Also, he serves on committees of AIPPI and LES. So, Shinji, we are pleased to have you with us today. The floor is yours.
Thank you. Just before starting, I and Vincent have what minutes? It's 5 or 6, so
Yes.
maybe. So
Yeah.
maybe it's a bit long. So I will try to shorten my presentation. Okay. Can I see slides?
Yes, we can see.
Okay. So today I focus on this new trends in sports industry and IP and sports data, artistic sports and esports. Next. Okay. So this slide just premise. So let me skip this slide. This for many rights in IP, trademark, design, publicity, naming, a pattern and utility model. It's all related in sports industry. So next one. Yes. So this slide regarding sports data. Sports data, which has become one of the most valuable assets in the modern sports industry. In sports-related data include a wide variety of information, such as match event data, performance statistics, and tracking data, and athletes' biometric data, etc. So indicated on the slide, the raw data itself is often difficult to protect through Japanese copyright law. Therefore, in practice, it's important to consider protection under Japanese Unfair Competition Protection Act. So if sports data is managed in a manner that satisfies the legal requirements for a trade secret, namely usefulness, secrecy, a non-public nature, qualify as limited access data, which must meet certain requirements such as substantial accumulation and electronic management, the data owner may seek remedies against unauthorized use. However, as shown on the slide, there is an important limitation. So suppose a third-party athletes. So the fourth one. Yeah. Third party attends a sporting event and independently collects much data for its own business purpose. In the case, the organizer generally does not own the independently collected data as a trade secret or limited access data, because the collection and management of the data are carried out by the third party. So as a result, statutory intellectual property protection law is often insufficient. So contractual measure is important. So let's move on to the next slide. Yes. Okay. So this slide says discussing about the protection of choreography and performances in artistic sports. So for example, figure skating and rhythmic gymnastics. These sports are unique because even though they are competitive events, they involve more than merely functional movements aimed at determining the winner. Rather, they inherently incorporate the bodily movement that are intended to express artistic idea and to be appreciated by spectators. So under Japanese law, under Japanese copyright law, this copyrightability is here. There is a definition of copyright work, and also there is a performance rights or generally recognized when a person performs a copyrighted work or engage in an art that possessions an artistic or entertainment related character. So not going into detail, but here the point is these artistic sports may be protected, these performances may be protected by this copyright and the rights of performance under Japanese law. So let's move on to the esports. Here, there is an esports definition. there's a standard for real-time broadcasting of batch video streaming platforms nowadays. And also next slide, there is a game publishers or team players, organizers, event organizers. There's many stakeholders in esports. And also, okay, this slide discussing game itself protection. And slide 7. Yes. So yeah. So under Japanese copyright law, it's a different element of a video game may be protected on a different categories. So a computer program enable the game to function is generally protected as a computer program work, where images or the visual content displayed on the screen during gameplay, or generally protected as cinematographic work. So these 1 and 2 is a possible protection under copyright law. And also if these esports based on films or so-called manga or any other novels, in that case, so there is a protection for the original work. So that is the number 3. And just briefly mentioning, and go to next slide. As musics. So for musics incorporated in the game, if there is a number 1 lyricist in the composer and the record label, these stakeholders maybe have the copyright of the music. And also in practice, many musical works in Japan are administered by JustRack. So for in that case, obtaining the licenses from JustRack by filing an application with JustRack is important. Next one is performers. So a music artist or voice actors in the game. So, okay. Yeah, when a game incorporating the performance is merely exhibited, streamed, or otherwise made available to the public, the authorization of the performance is generally not required. First one, A, because this is because Japanese copyright law adopt the so-called one chance principle, under which the relevant rights are largely cleared when the performer is lawfully incorporated into cinematographic work. But there's an exception here, B. If a broadcast or exhibition of the gameplay is subsequently recorded onto a separate sound recording, then obtaining consent or license is required. And then, okay, last one. Yes, finally, esports players themselves, are they protected under copyright law or not? That's a very uncertain issue. So at present, there is no established consensus on this issue. Nevertheless, it's possible to argue that highly skilled players who captive audience through their exceptional gameplay should be afforded protection as performers under the Copyright Act. For example, rhythm game, these performances may be protected. So compared to conventional sports, for example, baseball or football or soccer, these action of the athletes are generally not regarded as performance for the purpose of performance rights. But as I mentioned, in figure skates or rhythmic gymnastics may be protected. So in this case, depending on the genre of the game, esports players may be protected under copyright law in Japan. And that's it. Thank you for your attention.
Thank you, Shinji. And next, our final speaker, Vincent. Liew. Let me introduce Vincent very quickly. Vincent is a partner at Richard Lee in Kuala Lumpur, Malaysia, where he heads the firm's intellectual property, technology, and data practices. He's also a registered patent, trademark, and industrial design agent in Malaysia. Before joining the firm as an equity partner, Vincent served as regional IP counsel at Grab, where he gained valuable in-house experience managing IP and technology procurement matters across Southeast Asia. His practice today spans IP advisory, registration and prosecution, litigation and enforcement, licensing and commercialization, as well as technology-related matters. Vincent is actively involved in the international IP community. He serves on committees of AIPPI, Inter, and APAA, as well as the Malaysian Bar Intellectual Property Committee. He regularly speaks, writes, and contributes to discussions on emerging intellectual property and technology issues. Thank you, Vincent. The floor is yours.
Thank you very much, Chihiro-san, for the kind introductions. Good day, everyone. My name is Vincent Liew. I'm a partner at Richard Lee Chambers, a member of Grandeur Law Firm based in Kuala Lumpur, Malaysia. I head the law firm's intellectual property, technology, and data practices. It's truly a pleasure to be joining all of you today. From where I practice, when people hear the words intellectual property, they usually think about luxury brands, food and beverage businesses, or consumer products. If we talk about IP rights, the conversations almost always begin with trademarks and perhaps some patents involving manufacturing or technology matters. Very few people would naturally associate sports with intellectual property. So rather than talking about legislation or case law, actually today I would like to share about one simple idea, that is a sporting event is actually an intellectual property ecosystem, like we can see here. Let's start with something familiar. Imagine that we are watching a FIFA World Cup match tonight. I would like you to look beyond the football itself, of course. How many intellectual property rights can you identify? We have the FIFA logo, then we have jersey, we have the football boots, the trophy, the mascot, and of course the broadcaster graphics. Even the player names, images, match data, almost everything we see carries intellectual property value. More importantly, these assets are protected by different forms of IP. Some are trademarks, some are copyrights, some are industrial designs, some are patents. Therefore, my first key takeaway is simple. A sporting event is not protected by a single IP rights. It's an ecosystem of overlapping IP rights. So in this traditional sports, once we recognize the IP rights, another questions naturally flows. Who actually own these rights? Because we have the different stakeholders, like you can see on the screens. We have athletes, event organizer, league, broadcaster, club, and event sponsors. So this is the IP ownership roadmap that I have prepared. For example, for football, many people would assume everything belongs to the club. In reality, ownership is much more fragmented. Clubs own the brands, merchandise. Athletes may own rights relating to their names, images, likeness. Sporting associations own competition brands, for example, FIFA, Olympic. Broadcaster then own rights in their broadcast productions. Sponsor then obtain these valuable commercial rights through licensing arrangements. So every stakeholder owns a different piece of the commercial ecosystem, like we can see in this roadmap. So it's almost never, I would say it almost never owned by a single individual or single stakeholder alone. So it's an ecosystem of overlapping IP rights. Then let me illustrate with a simple or famous case. Back then in 1987, in the United States, we have this case, San Francisco Arts and Athletes. versus United States Olympic Committee, USOC. So this dispute is revolving the words Olympic. Many people would assume the word Olympic is simply descriptive, but in reality, it is one of the most valuable sporting brand in the world. So in this case, the San Francisco Arts and Athletics SFAA organized the Gay Olympic Games. The event name appear on advertisement, brochures, letterheads, and merchandise. Of course, USOC wouldn't be happy about it and demanded the SFAA stop using the word Olympic. So this escalated to the court, eventually end up in the Supreme Court. So the court so ruled in favor of USOC because it's very simple. Of course, in US, they have this exclusive statutory rights. USOC possesses the exclusive statutory right over the word Olympic. Then, of course, the court decided the USOC was not required to prove the consumer confusion. So the implications for sports commercialization is this. Sporting event name can be a valuable commercial asset. So, for example, this Olympic, we can see, and of course, FIFA as well. Then we turn to something slightly different, esports, because now I believe esports is now the trend, is the sports of the next generations. So it's here to stay and becoming more popular. Then in this, at first glance, esports may appear similar because we still have players, we have these tournament organizers, we have sponsors. So likewise, the IP rights or the stakeholders should be stay similar rights. Actually, it's not that simple because in traditional sports like football, nobody owns the football. In basketball, nobody owns the basketball. Then in badminton as well, nobody owns the badminton. But in esports, usually the game developer will own the game. Like we can see in this IP ownership map for the esports, usually the game publisher will own the games. For example, somebody owns League of Legends, somebody owns Dota 2, and somebody owns the Mobile Legends, like in this picture. So I also have this illustration, a case study to share. Because still to short of time, I will just quickly go through. This is a very interesting case, Nintendo. So of course, we know Nintendo is a very super huge major game developer in the world. So they own this famous brand called Super Smash Bros. It's one of their famous games. Then there's this Smash World Tour also. It's one of the world's largest community-run Smash esports circuits. So more than 6,000 players participated. The organizers sought to obtain a commercial license from Nintendo, but of course, there were some negotiations taking place. Right before they struck a deal, the organizer announced that the championship and the entire 2023 circuit would be cancelled because due to these licensing issues. So the issue here was that to what extent the game publisher can control the commercial exploitations of the esports tournaments. So the implication of this case, of course, Nintendo maintained that the commercial tournaments required their licensing. So from this case, we can see that actually the tournament licensing or any organizer, if they want to run similar events using the game features or even the name branding itself, they need to get a licensing. It's a very obvious, even up until the broadcasting rights, sponsorship, partnerships. So this is what is this case about? So that's all for my presentation today. Before I end, I would like just to conclude because my title is who owns the game, right? So the answer is no one person, but many different stakeholders, each owning a different piece of the intellectual property ecosystem. Thank you very much. That sums up my presentation.
Thank you, Vincent, and thank you for everyone today. And we have one question to Ron. The question is, does this apply to trademarks filed before the amendment? Specifically, are there fees associated with overreaching trademarks that encompass unrelated subclasses?
Yeah, I think I think I already answered that question to the lady. Yeah.
Okay.
Type 4. Yeah.
Okay, good. Okay, then before we close, I would like to briefly introduce our next event. As you may know, AIPPI World Congress will be held in Hamburg this year. The Young Members Committee will hold the Young Member Forum on October 8th. This forum brings together young members from various countries every year and provides a great opportunity for networking. We would be very delighted if many of you could join us. I would also like to introduce another event. The Young Member Trilateral meeting organized by Italian, German, and French groups will be held as a hybrid event. We warmly encourage you to join this event as well. So thank you very much for joining the Young AIPPI Members Summit today. We hope you found the summit informative and gained useful insights from today's presentation. So we look forward to seeing you in Hamburg in October. So thank you, everyone. So